YMCA Child Abuse New York, Civil Lawsuit Rights, Attorney Andrew M. Stengel. In March 2026, New York State suspended the operating license of YMCA Bright Beginnings in Plattsburgh. Investigators substantiated findings of child abuse according to WCAX. The YMCA Board of Directors fired the CEO, COO, and the Bright Beginnings director. However, the board claimed it had no knowledge of any violations until the state issued its notice. That claim raises serious questions about oversight. New York State Police launched an investigation and the center closed. A parent whose 2-year-old son attended the center for about a year described learning the news at 8 p.m. He simply did not know what to do. That helplessness is something too many New York families understand. The YMCA's duty of care to children in New York. YMCAs and similar organizations are not just community centers. In New York, they take on a legal duty of care the moment they accept responsibility for a child. That duty requires them to hire qualified staff, maintain safe environments, and respond immediately when abuse surfaces. Furthermore, New York Social Services Law Section 413 makes child care workers mandatory reporters of suspected abuse. Therefore, any YMCA employee who witnesses abuse and does not report it may have broken the law. When leadership fails to report to state authorities, civil liability exposure becomes enormous. Institutional liability, negligent hiring, supervision, and retention. In New York, civil liability for child abuse at an institution like the YMCA rests on 3 legal theories. First, negligent hiring means the organization employed someone whose dangerous history a background check should have revealed. Second, negligent supervision means management failed to monitor staff who had access to children. Third, negligent retention means the organization kept an employee on staff despite clear warning signs. For example, if prior complaints against YMCA Bright Beginning staff went unaddressed, the organization may have been negligent in retaining them. Additionally, supervisors who witnessed warning signs and looked the other way created exactly the kind of failure New York courts hold actionable. The cover-up problem, when organizations fail to report. One of the most damaging facts in any child abuse case is an institution that knew about a problem and did nothing. In the Plattsburgh YMCA case, the board claimed it had no knowledge until the state acted. That raises a direct question: who knew what and when? New York institutions carry a legal and moral obligation to report suspected abuse. However, organizations often put reputation and funding ahead of child safety. As a result, abuse continues longer than it should, and more children suffer harm. Deliberate cover-ups and systemic failures alike create grounds for civil liability and, in extreme cases, punitive damages. What evidence matters most in a physical abuse case? Physical abuse cases against institutions turn on documentary evidence. OCFS investigation reports carry particular weight because they reflect findings by a state agency. When the state substantiates abuse, that finding directly supports a civil lawsuit. In the Plattsburgh case, the state's suspension of the facility's license is exactly the kind of official record that anchors a strong civil claim. Prior complaints matter enormously. Internal incident reports, OCFS records, disciplinary files for staff involved, and any surveillance footage are all critical. Your attorney will send a litigation hold letter immediately to stop the institution from destroying those records. In New York, a defendant that destroys evidence risks an adverse inference instruction at trial. That means the court may instruct the jury to assume the destroyed records damage the institution's case. A civil lawsuit is entirely separate from any criminal investigation. Even if prosecutors never file criminal charges, a family can still pursue a lawsuit. The legal standard in a civil case is lower than in a criminal prosecution, and the potential recovery is significant. In New York, families can seek compensation for therapy costs, pain and suffering, emotional distress, and other losses. Most importantly, a civil lawsuit creates a public record of what the institution did and failed to do. That accountability matters for the family and for every other child who depends on that organization. Contact the law firm of Andrew M. Stengel, PC, for a free consultation. The law firm of Andrew M. Stengel, PC, represents families across New York in civil lawsuits against institutions that fail to protect children. We know how to investigate these cases, identify every responsible party, and fight for maximum recovery. If your child was harmed at a YMCA or any other youth organization in New York, we are here to help. Contact us for a free, completely confidential consultation. Email info@stengelaw.com. For more information, please visit our website, stengelaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.